Welcome to the ArtMiabo podcast, the show where we talk to fine artists, creative minds, and cultural backers from the African continent. I'm your host, Gift Nyadike, and with me today is Miss Rita Chinda. Thank you so much for joining us.
Thank you for having me, Gift. My name is Rita ANWIRI CHINDAH. I'm a law lecturer at the River State University. I also own an intellectual property and media brand called IP Series. I got to see IP from the international perspective and also how little things can be, taken to court. Back home, or within Nigeria and within Africa, you find out that a lot of creatives did not take their expressions seriously. It was more or less considered as an hobby. In every sector, you're going to see either a creative element or an innovative element. I say from my experience as a lawyer and also someone who started who joined the intellectual property space before becoming a lawyer, I would say the percentage of African creatives in terms of their awareness as to how intellectual property operates has increased.
I think earlier we talked about social media and how oftentimes something being put out there, people assume that it's free. But I do think that sometimes putting your stuff out there on social media, which a lot of Africans do across Africa, there is often the case where the protection is either not apparent or you don't explicitly put your protection there, whatever your trademarks might be. So what are the biggest risks that somebody might be exposing themselves to from posting their artwork or like, because I've seen this in the writing space. I'm a writer myself, so I've seen this in a lot of writing groups. Someone will post an entire chapter of their book because they're trying to get feedback from fellow writers. You're also taking your work and just putting it out there for other people to see. So, what are the biggest risks that creatives and artists are exposing themselves to? And also, can you share maybe some real examples of how things can go wrong or where someone actually had to maybe even come to you for help, where, they put their stuff out there and
Okay.
then somebody else sold it?
So a few weeks ago, I had someone reach out to me that, interestingly, this author had sent her a copy of her book, right? And I don't think she had read the whole thing, but someone else who had read the book because it wasn't launched yet had to call her to be like, "How did I did get a copy?" And she was like, "If you go to this page, you see that a full, like more than 3 pages of your work was reproduced in that book." So the conversation was, your former manager gave me consent and you didn't have an issue with it. So first of all, when you put your content out there, remember I said that copyrights as a form of IP is the only IP that gives you automatic protection. However, in the event you want to take further steps, you now have to consider what your IP system, whether they do a depository system or you have to formally register that copyright in question. Now, when that happens, you find instances where you post the content and in 24 hours, your book or your song is being circulated on various platforms. So one of the major challenges would be ease of reproduction and distribution from third parties that were not even authorized to reproduce your work or to distribute your work. And that becomes an issue. Then for authors, most times you will deal with plagiarism where someone is copying your work in verbatim, right? Without your consent. They're not getting your consent. They just assume that they should. So under copyright, you have what is known as technological protection measures, whereby a copyright owner will put in measures to ensure, or in form of encryptions or password, to ensure that some person doesn't go as far as accessing their work without their consent. We also had a case in Nigeria where a uh, sports photojournalist, right, created a course material and he was selling it. And some other person, someone, and his group of friends agreed that one of them would pay for the course, then they would break the encryptions that was needed to access the material and then share it with any other person that was interested in that material. So you find out that with the digital age, ease of reproduction is like one of the major things. How are you thinking of how to bypass the codes or the encryptions that are put in place to ensure that, oh, for you to get this you need to pay or to access? I think they used to do it on Tidal years ago where the likes of Beyonce and J. Cole will be like, you can't get this song on Spotify or on Apple Music except for Tidal, and if you're not
Yes.
using that app you cannot. Yes, so those are measures that you find out that creatives put in place to ensure that their works are also not reproduced. They are going to be dealing with now that you're having AI conversation, you're going to be dealing with unauthorized training and data scraping of your copyrighted work. And we've seen, I think there are currently about 50 cases filed mostly within the US. And there's some other jurisdictions that are experiencing this conversation. I know a few months or early this year, the UK, after several consultation with the creative sector, had to come up with a proposal that any AI company within the UK would need some sort of licensing model to be able to use those copyrighted works within the UK to train their models, right? The conversation is still ongoing.
Yeah.
Then some other one would, what other challenges would be having to deal with people who do not see anything with online privacy. So for us here in Nigeria, our copyright law makes provision for what is known as a takedown notice. It's known as a DMCA in the US, where you can send a notice informing the hosting platform that the content on there actually belongs to you and not the person that has put that content there. So that content will be taken down. I think a more practical example would be with YouTube, where someone reports your content and the music gets taken down or the video gets taken down. There have been several cases like Bad Bunny had to report or basically sue a fan who had uploaded one of his performance in one of the cities, like a full performance and all that. You also notice sometimes that when I think this Justin Bieber's Coachella's performance, the full performance was posted on X, formerly Twitter, and I did see and I liked two of those videos. But as of this morning, I saw that that post had been disabled, right? So you're dealing with those kind of conversations where do you then draw the line as to what you can use? So which is where, well, I'm not talking about what is known as defense of fair use or fair dealing, depending on your jurisdiction.
Yes. There you.
This
So I was going to ask
defense
you
is
about that.
basically, so if you use profit from that copyrighted work, right? So you're using it for private use to report news reporting, you're doing the research and all of that. But in the event where it goes outside the purview of private use and parody, pastiche, and the rest of them, then that means you are infringing on that person's work. There's what is known as the four-factor test in the US, and we also kind of reproduce it in our own Nigerian law, where the court will view your use based on those four principles to determine whether the use of that copyrighted work is actually falls within the fair dealing principle or the fair use principle, or is actually an infringement. And if it doesn't, then you're going to be held liable for infringement. Some jurisdictions already have stipulated amounts for what you may get in the event where you're found guilty of an infringement, right? So those are some of the challenges. But one of the I'm going to talk about, because it's not that bad for for you to upload it, especially now where everyone is trying to be visible and create like sure that you have like digital footprint around. I did see a post on X last night about a book author who I think she published a book 3 days ago, and she immediately got a film deal from Anna Hathaway, everybody's favorite princess, right? So she did write a book about a trad wife influencer who went back in time to 1885 to actually experience, who got to experience what being a proud wife is and not what she was selling online. So that's like the good part. You might also get, deals from persons who actually like your content. There is currently a sports related copyright dispute where an illustrator is calling out brand for or a sporting organization for using her illustrations on one of their merchandise products, and they didn't reach out to her to get consent to use that illustration on the merch that is being sold. So sometimes you find out that it might be a good thing to put your content out there, because at the end of the day you need like a digital portfolio or to put your brand and your content out there. But sometimes you find out that there are people who are willing to take advantage of the nuances such as cross-border related enforcement, right? In the events where you have, and I think this was a few years ago, where a Nigerian artist was calling out some other person in, was it Uganda or Kenya? I can't remember the African country. But the person had basically used one of his artwork to as one of the murals that was being drawn on a shopping mall that was to be launched or something. and there was no communication to say, oh, we like your artwork, we want to use it as our design on the shopping mall. Nothing was done. So I don't know if that design ended up being taken down, but those are some of the issues you find with, when you put your content out there, people are willing to just take advantage of the fact that you're not within their country. Because when IP related dispute arises, you're going to have to determine whether you're going to rely on their jurisdiction governing law or your own governing law, and what form of IP dispute resolution mechanism that you may want to explore. You're also going to be dealing with issues as to misappropriation, where some persons might use your work out of context and will never want to acknowledge you as your original source. You're also going to come across fake and counterfeited products or works that are not genuine or original or authentic to the creative involved. So those are some of the issues that, creatives basically face.
For an emerging artist in Nigeria or elsewhere, a lot of them, they don't have easy access to legal support, especially when these instances occur where their IP has been violated. But like, if you're trying to get in, let's say somebody is fortunate enough to be watching this episode right now and they're thinking, I want to get into art, I want to create something and put it out there. What practical steps can they take right now to protect their work in the event that they can't, they don't have quick access to a lawyer or any other form of counsel, especially like we mentioned, the age of AI and other tools that can generate art in seconds and train on, of course, real people's work. What can somebody who doesn't have that easy access to legal counsel, what can they do?
I kind of have like um a diverse view when people say they don't have access to legal services, because I think and I believe that you do not understand the commercial value or the value of what you have, and you also do not see the need why you need to work with a lawyer until there's a dispute, right? It's kind of like how when you want to start a business, you want to do a registration, you're going to be looking for a lawyer or a law firm or any professional that is designated, or that have been part of the qualifications that these are people that you can work with. And so you not wanting to even have a lawyer, because there are different categories of lawyers. There are lawyers who do various form of law. So if you're in the creative sector, whether it's film, entertainment, media, whichever area, you should look for a lawyer first. I mean, you can, start with a lawyer that you can grow with, right? That's one. The second practical step would be having to make inquiries as to what element of your creativity can be protected. Once that is sorted out, you go to the necessary IP office within your jurisdiction and do the necessary registration. Then document everything you're doing so that in the event of a dispute, you always have something to fall back on. That documentation, when someone comes and starts making a case saying you stole their work, you don't really have any proof that you're the original author of that work. With AI now, I would say everybody needs to educate themselves as to what are the benefits of using these AI tools out there, especially now that especially for musicians, where you have your AI music generators, or you use other AI tools to create artistic works or record your podcasts and stuff like that. What are the terms and conditions for using such platforms? You also need to see your creativity as a form of data. Right now, data is king, or is like one of the most important thing, because with that data you can do a lot of things, you can control a lot of things, you can make money from that data information that you have regarding your content or your creative work. If you're going to go into collaboration, ensure that you have a contract. Let's see you dotting your I's and crossing your T's and signing the right documents. If you get a contract from someone, ensure that you give it to a lawyer, because you find out that in most music contracts, there's a clause that states that you have given a lawyer your documents to read. So you won't come out tomorrow to say someone took advantage of you, or you were coerced, or you were desperate or something. Ensure that the lawyer explains what each of the clauses mean. If it's not to your benefit, you can always renegotiate. And then what else? Some jurisdictions have what is known as an IP help desk. I know the EU has something like that. Also, the World IP Day that's the intellectual property organization, has a designated day, which is every April 26th, where they designate a particular team. This year is IP and sports. And most law firms or individuals within the creative sector would be offering pro bono services. So you have to take advantage of any pro bono service that you find available within your country. Some IP offices also do pro bono services for creatives other than just educating them. So now I don't think anybody can say there's not enough information or they don't have access to legal services. I highly doubt that, right? And also because of the fact that I'm sure we've all heard about the AFTA agreement. The AFTA agreement makes provisions. There's an IP protocol, there's a dispute resolution protocol, there's a digital trade protocol, and all of those, and a competition protocol. And the goal is one single market. So how are you positioning yourself to ensure that when all of the African countries ratify and adopt this agreement, how is it going to benefit you as a creative? How do you intend to collaborate with someone from North Africa or West Africa or South Africa or East Africa? How are you positioning yourself? You also need to put in the groundwork and take advantage of social media now, where you have to consistently come through for yourself, be visible, take advantage of I mean, you're in a different jurisdiction. I'm in Nigeria and you're in South Africa, and we're doing this using a virtual platform. So there are now more opportunities, but you just have to be wary of things like cyber breaches, data breaches, sending data to the wrong persons, being aware of what the privacy concerns may be, what the advertising or marketing rules or guidelines might be within your country, and any other regulatory compliance that may be needed for your sector. There are also room for institutional transfers where you might want to take advantage of, say, a collective or a hub. For us here in Nigeria, the Minister for Art and Culture, I've set up a couple of activities to engage the creative sector. So you also need to put in the groundwork by doing your investigation as to what are those opportunities that are available within your country.
Thank you very much for that. I hope you all were listening. But yeah, and that was something for very important for myself as well to learn. So thank you so much for that. Final question.
Okay.
African art is, yeah, it's African art is often inspired by a shared heritage, tradition, and community, you know. So how do IP laws handle a cultural or collective ownership? And is there, well, there is a risk, but the risk of like African culture being exploited globally without the proper credit or compensation, as you mentioned, being misappropriated or just, cultural appropriation. That's a prevailing conversation has been for decades upon decades. I
Yeah.
want to use the example. I know this was like 16 years ago, which is crazy to think about, but the example of the 2010 World Cup, which was hosted here in South Africa. The official theme song was Waka Waka, This Time for Africa by Shakira, which
Uh-huh.
sampled the original Cameroonian Makossa song Zamina Mina Zangalewa by Golden Sounds. Officially, at the time, it wasn't ruled as plagiarism. But what's your take of that in relation to my original question, my original point there?
Okay, so the traditional IP system is more about individualism, right? So the author. But when you're discussing cultural heritage, cultural IP work, which is like a collective or community owned product, you're going to be interacting with non-traditional IP or uncommon or unpopular form of IP, such as traditional cultural expressions, your folklore, your genetic resources, your traditional knowledge, geographical indication, things like that, right? Now, for community owned IP, it's more about passing information from one generation to the next generation, ensuring that the authenticity of that property, intangible property, is preserved. However, because the traditional IP focuses more on being monopolistic and commercializing, making money, the community is all about preserving knowledge and sharing it within them. In the events where you want to monetize a cultural IP, you need consent from everybody in the community, not just one person. So I'm going to give you as before I answer the Waka Waka case, I'm going to give you a story or talk briefly about the Kenya Maasai tribe fabric. I don't know if you've seen that checkered fabric that most luxury brands were using at some point to create products,
Yes, I do recall
right?
a story like that. Yes.
So what they had to do, the Maasai tribe had to engage a lawyer and also create like a community advocacy group that would monitor the use of their fabric without their consent. That's an example of a cultural IP. If you also look at it from the folklore aspect, our traditional songs, our stories, there is I don't know how to say this, but there's this thing where people say Thor is similar to the
Yeah.
Shango story. I'm sure you've heard about that. But you find out that with
Yes, I
folklore,
heard it,
there are
but
always there are always different interpretation and expression of the story of God of Thunder or the
yes,
mermaids, which we call Mame Water in Nigeria, all of those
yes,
things. So for community owned IP, there are certain treaties basically, but most jurisdictions or most countries in Africa do not have like express law protecting this cultural IP because it's considered to be very sensitive. So in South Africa, they have the robust tea. I'm sure you know the robust tea. At some point, it was in dispute
yeah,
because some non-South African wanted to monopolize and commercialize robust tea for themselves. And it's not the first time that African products, whether as agricultural products or non-agricultural products or our songs and music, someone wants to take it out of Africa to their own territory where they have more control. Because remember, I stated that intellectual property is territorial in nature. And because the world at that time wasn't as digital as it is, so it was easy for anybody to take anything out of Africa and go and make money from it without, the owners of the original work even being aware of it. Now, back to the Waka Waka story. I know that when that conversation came out as to the fact that it was, plagiarized, there were conversations between FIFA, the artist, the producer of the song, and one other person as to what to do in terms of paying royalties to the family because the original owner of that song died, I think, in 1962 without any form of compensation. But sometime in 2004, the family settled out of court with uh, the company. However, there are conversations or allegations that the proposed royalties that were to be paid for the unauthorized use of that song never got to the said charity that was touted as one of the terms for paying or compensation for the unauthorized use of that song. We also have the case of The Lion Sleeps Tonight. That is another form of African music that was taken out of Africa to another jurisdiction. So it's not the first time.
yes,
What I would say now is that because the world has now become a digitized and global community, it's easy for you now to track any form of unauthorized or any form of misappropriation. We had a case in Nigeria, I think sometime I can't remember what year now, where someone tried to trademark Yoruba in the UK, and it was a full blown conversation online. So what I would say is we need like a proper cultural IP document that protects Africans. We also need to start documenting creativity, our cultural IP. I mean, intangible cultural heritage is now a hot topic within not just the IP sector, but because it interfaces with every person, your identity, the indigenous people, what are their rights? What rights do they have over their work? In terms of I want to use a community's work, I need to get prior consent from them. You also need to sign what is known as a benefit sharing contract, depending on the kind of IP that you want to use. If it's for musical work, you're expected to collaborate or work with the artists or the musicians that came up with that song. And also ensure that the contracts are fair because the reason why the Waka Waka case came about was because what? Other than the fact that the authors were not properly acknowledged, there were issues post that event which stated that the contracts that were signed prior to Shakira coming into place were not beneficial to the original owner, which is why they never got to make profit from their song. So we also now need to be wary of the kind of offers that are being given to us. Ensure that, I mean, I know people don't like hearing bring a lawyer, but ensure that the lawyer that you're bringing to the negotiation table has not just an interest or experience in intellectual property, but in that creative niche industry that the conversation is being heard, right? The creative sector is so massive that there is room for everybody to grow, but we need more people to be aware of their intellectual property rights so that they are not taken advantage of. If you're going to license, let it not be a license in perpetuity, and then the royalty scale is not something that ends up benefiting you, because when you're discussing royalties, there are different approaches as to how royalties are also being determined at the end of the day. So I mean, there's room for improvement, but there's also need for us to ensure that our identity as African creative is not just commercialized to the point where we lose our identity as African. Let the authenticity of that African story or African poem or the dance, the murals, the fabric still have elements of the African cultural IP so that you appreciate it more. We also need to see that with, collective IPs such as your cultural heritage, traditional cultural expressions or traditional knowledge, right? Everyone has to be part of the process of documentation so that it doesn't fizzle out and die. And then some other researcher who may be non-African try to make it seem like, oh, I just found something new, whereas it's been there, but because of lack of documentation. So
Yes.
on uh we need to improve means of documentation and ensure that the right people are in the room when negotiating this. So we don't have people that are less informed as to how cultural IP works or traditional IP works, and then ends up selling out the whole community. Then you're not back in court, or you are in an international dispute resolution panel trying to see how you can get your rights, indigenous rights, from someone who is looking at it from the big commercial or monopolistic angle. At the end of the day, you also need to determine what elements of your cultural IP should be commercialized. If it's going to be commercialized, what elements of those cultural IP should be commercialized at the end of the day, and the documents should um be signed to ensure that it's not misappropriated or appropriated by the wrong persons, and have good enforcement policies. Also engage the government. I think one of the major project problem we may have is that our government hasn't really seen the commercial value of what IP can do or generate for us. If you look at South Korea's template as to how they built their creative sector, that the K-pop brand itself is selling out everything. I mean, yeah, Goldie K-pop Hunters went viral last year. Golden
Yeah,
is like one of the biggest cultural So bring it back home. I mean, we do have a Nigerian animation called Iyanu, but it's not as popular as K-pop. So
yes.
what do we do in terms of getting the right investors into our business to invest in cultural IP? Do we adopt a public-private partnership or a joint venture? How much can you share? Remember again, is who owns the IP that gets to control what economic right that may be coming into play. So don't give out too much, but give out something that can be monetized and also preserve your authenticity. It's kind of like when a startup is looking for funding. The moment you start giving out pieces of your company, you get to lose control over certain decisions and how the model or the original business idea can, grow and take place. But yeah, I mean, there's prospect. I mean, we're happy that everyone is doing Afrobeat to the world. We're having like Afrobeat fusion with the Latinos and the rest of them. So there is hope. And Africa is a big continent. I mean, we're 54 countries.
Yes.
So there is prospect for everyone. After agreement works gets to work, it's actually going to be beneficial to everyone. But I think in conclusion, and I was having that conversation with my friend this morning, and we're saying we need to do away with this visa issue so that if I want to leave Nigeria to South Africa or to Kenya or to any African country to create or do some sort of research on what culture, because Cultural IP is interesting. The problem is
Yes.
we are not documenting enough to the point where people will be interested in wanting to learn cultural IP that is currently ongoing, where people are using cultural IP as a way to generate revenue without actually putting the work in terms of documentation and preserving those creative elements that we have and are unique
Yeah.
to the indigenous people. And at the end of the day, they end up infringing on their rights. But yeah, that's basically it.
Yeah, I think a good example, I think would be like the Grimm's fairy tales. You know, those famous ones, your Red Riding Hoods, your Goldilocks and Three Bears, all these various princess stories like Snow White and the like. These were all folklore that had existed for hundreds of years prior to the Grimm's actually putting them into a book, into a collection of stories, and they became the definitive versions of these stories. So that is something that, as a collective Africans, we need to actually be doing. Ms. Rita Chinda, thank you very much for joining us for this episode. It was a wonderful
Thank you.
conversation, very
Thank
educational.
you for having me.
Yes. If you enjoyed this conversation, please be sure to leave
Thank
a
you so
like,
much
a
for
share,
having
a
me.
subscribe, and a comment as well. Yes, thank you. This has been the ArtMiabo podcast. We will see you next time.